Hi everyone who's just joining us. Welcome to the webinar. We're just going to let everybody enter the webinar room and then we'll get going. It takes a minute or two just for the numbers to settle. Hi everyone who's just joined us. We're just going to let a few more people come in from the waiting room into the Zoom space and then we'll get going. Hello everyone. I'll start going with the housekeeping for today's webinar because I can see the numbers are starting to settle a bit. So welcome to another webinar from the TUC. I'm Anna and I'm joined by Rebecca Thomas from the EHRC, but I'll get onto her a little bit more in a second. As usual, we're recording today's webinar, and if you miss anything or you've got to leave for some reason, don't worry, because we will send you a link to the recording first thing tomorrow morning, and we will also include any resources that we mention or that Rebecca mentions, any web links. So don't worry, you won't miss out on any of that. We do have live captions for the webinar. There's a button underneath the videos at the bottom that says CC. If you click that, you'll be able to see captions along the bottom of the screen. I can see some of you already saying hello and introducing yourselves. We love to hear that, and we love to see what's going on in workplaces. So do please use the chat panel, which is on the right-hand side, to tell us about what's going on in your workplace, and any tips you might have that you might want to exchange with other viewers. And we will have time to put some questions to Rebecca after I've asked her some questions. So do please post those in the Q&A panel, which is at the bottom of the screen. It looks like a speech bubble with a question mark in. Put any questions there and I will get to as many of those as I can after the main bit of the webinar. And we are also going to issue you a digital credential if you join us live. That is evidence that you've done the webinar, and look out for that on your email. So, as I said, I'm joined by Rebecca Thomas today, and she's from the EHRC, and we're going to be talking about a new duty on employers. So there's going to be a duty for employers to take steps to prevent sexual harassment in the workplace. So that might sound a little bit complicated. So I've got a list of questions that I'm going to ask Rebecca, and hopefully we'll get lots of important information from her that will help you in your role as a rep. But first of all, Rebecca, welcome. Can you just tell us a little bit about who the EHRC are first, and what you do for them?
Yeah, for sure. Hi, Ansa, and hi, everybody on the call. Really delighted to be able to join you this afternoon. It's really timely. We are well aware of the important role that reps play in the workplace in terms of ensuring that members' rights are upheld, and actually providing employers with a really good and strong basis to implement steps that they can take to protect their workers from discrimination and harassment. So there's a real benefit to me being here today, and I'm really looking forward to hearing some of your thoughts and your questions. I have to apologise in advance in case my cat decides to join us. She is a staunch defender of equality and human rights, particularly in the workplace. And I did try and feed her before we came on, but no, she's decided she wants to join. So yeah, she's just walked across my keyboard. Apologies.
Great stuff. Any extra speakers, performers, we're all good.
You might get a meow from her. Anyway, so the EHRC, we're the Equality and Human Rights Commission, and we are here to enforce equality law in Britain. We are also an independent A-status national human rights institution, so we are responsible for ensuring that there is compliance with international human rights obligations, but that's directed more at the UK government and the Welsh and Scottish governments. So in terms of our enforcement of the Equality Act, obviously this new legal duty that Anna, you mentioned just now, amends the Equality Act. So it sits directly with the EHRC to enforce and ensure that people understand their obligations and their rights under the legislation.
Thanks, Rebecca, for that great introduction. And someone posted in the chat, it wouldn't be a proper Zoom call without a pet. So I think, you know, your cat is going to bring it on. Okay, let's get down to the subject of what we're here to talk about, which is this new preventative duty. So my first question, what is this new legislation and what does it mean in practice?
Sure. So as most of you will be aware, we've had the Equality Act since 2010, and that has always been clear that sexual harassment is unlawful. Sexual harassment in the workplace is unlawful. But what we found over the past sort of 10 or so years is that despite these existing protections, sexual harassment is still taking place. It's widespread, it's underreported, and it's poorly enforced. Just to be clear as well, so sexual harassment under the Equality Act is unwanted conduct of a sexual nature which has the purpose or effect of violating a worker's dignity or creating an intimidating, hostile or degrading environment for that worker. So as we know, the legislation has been in place, but the EHRC did research into the kind of the nature and the extent of sexual harassment back in 2017 in light of the sort of disclosures being made around the Me Too movement. And what we found actually was that, as I said, it goes underreported, that employer responses in terms of dealing with this are really poor or inconsistent, and that essentially there was sort of very little redress for individuals who might experience workplace sexual harassment. So off the back of that, we recommended that government implement a preventative duty. So what that requires is employers to sort of front load protections for workers to ensure that they are protected from sexual harassment. And that came through the Worker Protection Act, which received royal assent last year. But actually, the main bit of that, the preventative duty, came into force on the 26th of October this year. And as we said, that requires an employer to take reasonable steps to protect their workers from sexual harassment. If they breach the preventative duty, if they don't take reasonable steps, and I'm sure we'll talk about what reasonable is sort of further on, the EHRC can take enforcement action. Now, the other thing as well to bear in mind is that the Employment Tribunal can also increase compensation in a sexual harassment claim by up to 25%. So in terms of the preventative duty, what that is, what it does, what it says, that essentially includes a requirement for employers to take steps to prevent worker-on-worker harassment, but also harassment by workers of third parties. Now, it's important to sort of be clear that there is still no protection from harassment by third parties for individuals. So an individual can't take a claim to the tribunal because they've been harassed by a customer or a client at this point. That original protection was repealed back in 2013, and that's still not sort of been reinstated through the Worker Protection Act. But the way in which the preventative duty is worded in the Worker Protection Act means it just talks about sexual harassment that takes place in the course of employment. So it doesn't specify that it's worker on worker, which means that it could include harassment by third parties. And of course, in the course of the employment is quite broad. So it could be harassment that takes place in the workplace, in an office, in a hospital, in a shop, wherever. Or it could also be, accessing external training, attending a conference, or even socializing in the work context. So what it really does is sort of very explicitly state that the employer is responsible for harassment that takes place in the course of employment, and that is really quite broad.
Thanks for that clarification, Rebecca. I think it's really helpful to know who's covered and in what situations. So you said that this law came into effect only a couple of weeks ago, really.
Yeah.
It's very, very new. But where did it come from and how did we get to that point?
Sure. So as I said earlier, we the EHRC did a call for evidence back in 2017, and we got hundreds and hundreds of responses to that call for evidence from both workers and employers to help us sort of understand, as I said, the scale, the nature, the type of harassment that was taking place, what employers were doing, and to inform sort of practical solutions to address that, to make sure that people are better protected in the workplace. And obviously we work really closely with the TUC and many of the affiliates in terms of that project, but we also work with equality groups like the Fawcett Society and government and parliamentarians to try and sort of create a solution, a policy and a legal solution that would help address that. So off the back of the EHRC's recommendations, the government subsequently consulted on proposals to sort of create greater protection against workplace sexual harassment. And that happened back in 2019, but then it all went very quiet and nothing more happened. And it wasn't until I think, let's go back in the midst of time now, I think it was autumn 2022, Vera Hobhouse, who's a Lib Dem MP, took a private member's bill through Parliament that would introduce this preventative duty. And it was thanks to her doing that, the government decided, well, actually, this is a long-term commitment of the government, so we'll support it. And that's how we ended up with the legislation.
Thanks, Rebecca. So now on to sort of the nitty gritty. We know that this is a duty on employers. What in practice will this mean for them regarding the new responsibilities that they've got?
So the new duty is a reasonable steps duty. And what that means is that an employer is required to take reasonable steps to sort of consider and mitigate the risk of sexual harassment happening in the workplace. Reasonable is not defined, and obviously that poses sort of quite a challenge for both the EHRC in terms of enforcing this and providing, sufficient advice and guidance to employers and workers, but also to reps, because you're all going to be engaged with your employers trying to figure out what does reasonable look like in the context of your workplace. But essentially, the reason we can't be prescriptive is because what's reasonable for one employer is not going to be reasonable for another. But there are a range of different things that employers need to be sort of considering to determine what is reasonable. And that will include things like, the size of the employer, what resources it has available. It'll also be dependent on the nature of the working environment and the sector that the employer works in. So let me give you an example. The risks of sexual harassment, for example, in a hospital where there is a lot of interaction with workers, but also third parties, are going to be very different to somebody who works in a small office and is not front facing and doesn't have any sort of contact with clients. So what might be reasonable for a hospital to do is going to be very, very different to the owner of a small office-based organisation. So the other thing as well that employers are going to have to consider to assess whether something they want to do is reasonable or not would be around whether implementing a particular step to mitigate sexual harassment would be effective, whether other steps might be more effective. They also need to consider, kind of time and the cost and the potential of disruption of taking particular steps and weight those against the benefits that it could achieve. The other big thing, and I think this is really important for reps, because what we know from all of the evidence we've gathered is that sexual harassment is underreported. It's woefully underreported. So actually the true scale of sexual harassment is not known. What we know is that an employer might get formal reports of sexual harassment, but it's far more likely that there are going to be whispers and there are going to be rumours, or there are going to be disclosures made to reps or colleagues, and that individuals don't feel confident in terms of taking that forward and raising that formally with the employer. So it's really important an employer sort of considers, what's happening in the workplace already, where sexual harassment might have occurred. They also need to consider how they engage with reps and other worker representatives to see if they can gather additional insights to understand what's happening in the workplace. The other thing that employers also need to consider, and this is quite a technical one and probably not relevant for a lot of reps on, but certainly within the public sector and some private sector where there are sort of sector-specific regulators, is whether there are any other regulatory standards. So if you look, for example, at standards set by the General Medical Council in terms of fitness to practice, Financial Conduct Authority has similar kind of regulatory standards that require people working in financial services to be, fit and proper people. The other thing that is also really helpful, and again, this is where reps come in, is whether sort of previous steps that the employer has taken to sort of address workplace sexual harassment have been effective. So actually being able to kind of feed in, share insights in terms of whether that has address the issues that have been sort of, that have occurred within the workplace or not, and whether they need to kind of review, refine or take additional or alternative action. And finally, just to end, I think it's really important to emphasise is that a step might be reasonable, even if it wouldn't have prevented a particular act of sexual harassment. So, sexual harassment is always going to take place because this, people are people, and that's just a sort of an unfortunate truism of sort of modern workplaces. But there are a number of things that employers can do in order to try and mitigate that. And I'll give you an example of a step that would be reasonable. So, for example, one of the things that the EHRC advocates for is for employers to provide training so that all of the workers, whether they are, a manager or a managee or a senior member of the organisation, a director or a board member or whatever, have access to training so they understand what their obligations are, what their responsibilities are, what the new duty means and how that applies to them, what sexual harassment looks like, whether you witness it or whether you experience it, and then what the employer will do to support an individual if they witness or experience sexual harassment. Now, everybody can have training. You might still get instances of sexual harassment occurring, but it is a reasonable step, a reasonable preventative step to ensure that everybody in the workplace understands what sexual harassment in the workplace is and what to do about it if it occurs. That's absolutely a reasonable step. You might still get instances of sexual harassment, but it would still be reasonable to do the training, even though it's not necessarily stopped workplace sexual harassment.
Thanks, Rebecca. I think there's so many really good examples in there of what employers need to be doing, and we can't cover every single example, but hopefully people can, viewers can get the information from that they can apply in their workplace, and we'll be exploring some of these a little bit more as we go through. So as we've said, this is a duty not on unions or on workplace representatives, but on the employer themselves. However, we and you think there are things that reps can do in this process. So let's talk about some of those. What do you think some of the actions are that reps can take now we've got this new duty?
So I think the number one action now is for you to go back to your employers and say, you've got this new obligation, what are you doing? And to signpost them to EHRC resources and sort of challenge them on what they are doing to comply. And are they using EHRC resources, for example? But also we know the TUC has got a range of resources to support reps as well that are also really helpful. So, I mean, in terms of identifying what reasonable steps looks like within your organisation, absolutely yes, that's the responsibility of the employer. And there are a number of things that they can do in order to sort of consider and shape those reasonable steps. And we recommend a risk-based approach. So essentially what we're saying is that employers should undertake a risk assessment to think about what risks are present and take action to eliminate or reduce those risks. And there is absolutely a role for reps in terms of helping an employer consider risk and understand what that risk might be and provide advice in terms of whether particular actions or steps might be appropriate to take in that context. I think the other key thing as well is that this, compliance with this new legal duty isn't a one-time action. So it's not just, we've updated our policy and we've done training. we've got a reporting mechanism, tick, off you go. An employer is also required to sort of monitor and make sure that what it's doing is effective. And one of the key ways it can do that is by getting feedback from reps, to make sure that the actions it's implementing, whether it's training or whether it's having a policy or the reporting mechanism or, you know, other sort of reasonable steps, to make sure that those are actually having an impact and making a difference.
Thanks for that one, Rebecca. Yeah, I think that throughout this, the question that keeps coming up to me is we'll have to keep referring back to the test for reasonableness, I think. But we've had some questions posted about that, which I'll come to in a minute. Right, so what happens if the employer doesn't take these reasonable steps and fails to meet their duty? What would happen then, and how do we get to that point?
Yeah, so as I said at the start, if an individual cannot take a claim to the employment tribunal on the basis that the employer has breached the preventative duty, if an individual has a claim of sexual harassment at the tribunal and that's upheld, the employment tribunal can then consider whether the preventative duty has been breached. And if it decides that it has, then it can issue a compensatory uplift that is up to 25%. So that will tie to the award that's given for the harassment. So that's one way that the employer might be sanctioned. The other way is that the EHRC can take enforcement action. So as many of you probably aware, the EHRC is quite a small organisation. We have fairly limited resource. We are much smaller than we were back in 2010 when the Equality Act first came into power. So we very much take a strategic approach in terms of where we can take enforcement action. So it's usually where we can clarify the law, provide greater certainty in terms of legal obligations, or where there have been sort of particularly grievous breaches of equality law, so that we can absolutely make a difference and ensure that people are protected. So in terms of the EHRC's enforcement approach, if an individual considers that their employer is not complying with that preventative duty, the first step we would expect that individual to do, whether it's a rep or a worker, a member, or what have you, is to raise that with the employer and to sort of press upon them to find out what they're doing to comply. If that response they get back from the employer is sort of unsatisfactory, then they can raise it with the EHRC, and they can do that through our whistleblowing mechanism. So the EHRC is you can whistleblow to the EHRC if you are concerned about breaches of equality or human rights issues. So that can come into us, but as I said, the EHRC is we're very sort of tight in terms of our capacity. So we're not going to be able to sort of enforce every single breach of the preventative duty. And what we're going to need to do is take a very sort of strategic approach, gather evidence, sort of gather insights in terms of what's happening, where employers might be struggling to comply. Are there particular challenges in certain sectors or certain issues? And that's why we've produced a range of resources up front to try and support employers, and actually hopefully will help reps sort of hold their employer to account to make sure that they are putting steps in place that will sort of address the risk or the potential for sexual harassment in their workplace. And that includes things like really detailed technical guidance, which is basically the sort of definitive guide to harassment under the Equality Act and what the Worker Protection Act means, the preventative duty. But then we've also got sort of short form content. So we have an 8 steps guidance, which is actually probably a really useful resource for reps, because it sets out really clearly the type of actions that employers should take to demonstrate that they are complying with the preventative duty and doing everything they can to protect their workforce from sexual harassment. I know too that obviously TUC has got things like a checklist for reps that you can work through with employers to make sure that they are sort of considering all of the potential risks for sexual harassment and are implementing sort of specific steps to protect workers. And the other thing we are looking at is if you look at our technical guidance, that's actually another, it's very detailed, it's very technical, obviously, because it's the definitive interpretation of the law. But what it also has is a number of examples which illustrate how the preventative duty might work in practice and what employers are required to do. So that's another really good way of getting insight in terms of, you know, what might be reasonable in different contexts, what are the kind of practical steps that employers can take, and so forth. But really, it's as we said, you know, the onus is on the employer, and reps are really good sort of accountability mechanism, you know, the kind of the quiet voice, or sometimes not so quiet voice in employers' ears, reminding them of their obligations.
Thanks so much, Rebecca. I think we've got some really great detail and like comprehensive information on what this new law is and what it might mean. I'm going to have a look at the questions that we've had posted in a minute, but I've jotted down a couple of things as well of other things I wanted to know while you've been speaking. You mentioned just a minute ago about the role of the EHRC, and that, you know, if that you are going to be responsible for enforcement. But I was wondering about the rep's role in that. Is there going to be a minimum level of evidence required for a report to EHRC? What would you take as that minimum, or would it be a case of someone just giving you a call and saying, look, this is the case in my workplace? Or, you know what I mean? Do you need a load of backup information?
I think obviously the point at which reps are contacting us, the more information, the more evidence they've got, the better, because that will actually enable us to take a sort of a considered view on, you know, what is happening in their workplace. As I said, I think that the kind of the key thing is that, you know, the sort of contacting the EHRC shouldn't be the first port of call. As with any kind of workplace issue, the first point is to try and, you know, discuss that and resolve that with management. You know, and sometimes that's fine, and it can just be either, you know, they're not aware, or they need a bit of encouragement to sort of expand on the types of steps that they are taking to address workplace sexual harassment. So that should absolutely be the first point of the first sort of step in terms of reps concerns about non-compliance with the duty. But then absolutely, yes, contact the EHRC. We have an email address and we have an online form which reps can contact us through. The other thing as well to say is that I know that, you know, the TC is really active on this. It absolutely is a priority. And there is the This Is Not Working Alliance that's made up of affiliates and other equality groups that are interested in this and addressing this issue. And we know that affiliates are working really hard to sort of monitor and track what's happening in their workplaces with a view to upskilling reps, challenging poor practice or non-compliance as well. So I think there's quite a heady mix of activity going on that potentially will ensure it doesn't ultimately fall to the EHRC to enforce. What I would say, though, is that as with any legal change of this nature, this is not something that's going to happen overnight. There's going to be a transitional period, and it's going to take time to bed down. So, you know, the EHRC is not sort of immediately going to spring into action for non-compliance. What we want to do is to look in detail at what is happening, as I said, at how employers are responding, so that we understand where the challenges and the difficulties might be. And we fully understand as well, recognize that actually the kind of the reasonable steps bit is difficult to consider, because there isn't a one size fits all. What's reasonable for one employer is not going to be, you know, right for another. But every employer is subject to this duty, and every employer needs to do something. And reps are going to have a really good, really important role in helping shape what that something looks like. The other thing as well I wanted to say, because I'd not touched upon it particularly, but as part of the sort of the reasonable steps duty in demonstrating compliance, one of the big things employers really need to be doing is talking to their staff. And as I said before, we know that reps often hear far more than managers do, you know, whether that's line managers or senior managers within an organisation. But reps have got a really important role to play in terms of disseminating, raising awareness of what the employer is doing, as well as what it's not, obviously, and challenging that, but helping sort of raise awareness of the duty internally as well, so that employees are able to kind of properly engage and to draw in insights from across membership and a branch.
Yeah, thanks, Rebecca. I think that's a really important point about the role of the rep is you often do hear about things first, and hopefully you are able to, gather that information with your fellow reps if you're part of a committee, or with other active members in your workplace. So as a pool of information that will help any of this, no matter what area of work it is, really. It just happens to be this one, but that is being a rep, finding information, talking to your members, talking to management. Okay, we've had a question about what an employer should do with this new law. And that sparked off a few things in my head. So one of our viewers asked their employer in September, so before the law came into effect, about what they were going to do. And they were told that they're working on it. So what sort of things can we expect? Do we need, should we be looking for a brand new policy, a revision of an existing policy, or could it be bolted on to something? What would be best practice really for this?
So we don't specify what an employee should do specifically in relation to policy, but the bottom line is that yes, most employers are going to need to have an effective anti-harassment policy, and that could be some policy that deals specifically with sexual harassment and ones. And I think if you look at our 8 steps guidance, which I'm hopeful in the chat, she's not. That sets out really clear what needed in that policy. So it could be that an employer already has a reasonable policy and it just needs sort of refreshing
Rebecca,
or updating to reflect.
Can I just stop you there? I think we just had the last minute or so, a lot of interference. I thought it was just me, but
okay.
Can you just go back 60 seconds and say that again about the best practice? I don't think it was just me who got it, because there's a couple of other people saying that they heard it as well, and I don't want people to miss out. So yeah, what my question was is what can we expect from employers in terms of best practice?
Okay, is the sound okay now? Brilliant. Okay, so what I was saying is that we're not prescriptive in terms of what an employer should do in relation to policies, but we're very clear that actually, the vast majority of employers need to have an effective anti-harassment policy. So they can either have a single policy that deals specifically with sexual harassment, or they can have one that and another one that deals with other forms of harassment, or they can have a comprehensive one that deals with all forms of harassment in work. But what they need to do, obviously, is include detail on the preventative duty and what that means for workers. So if an employer has got an existing policy that you as a rep think is reasonable, it absolutely makes sense. No point reinventing the wheel. Just make sure that it's updated and that it's also enhanced by sort of insights that are being generated by, for example, an employer doing a risk assessment. So are there other points that an employer needs to pick up? Does it actually include things like, what the reporting mechanism? Does it define sexual harassment? Provide examples. Does it address third-party harassment? So even though there's no standalone protection in terms of an individual being able to take a claim, the employer needs to note of duty. It also needs to sort of set out clearly what the employer is going to do should there be concerns raised about sexual harassment and stuff. So as I said, there's no requirement to start again from scratch and create a whole new one, but absolutely we would expect to see a really clear and coherent policy that deals with all forms of harassment, but particularly sexual harassment in light of the preventative duty.
Thanks for that, Rebecca. I'll keep an eye on if we get more interference and sort of just jump in if it happens again. Okay. Right, you have mentioned a few times about some of the technical guidance that the EHRC has published, and I know we have put a link in the chat panel for you. We'll also send that out. It's also worth mentioning that we here at the TUC are, as I speak, working on a new or we are updating our tackling sexual harassment training so that it will include information about this new legislation. And we hope it will be with you in the next couple of weeks. But we are on it, and watch this space. But you know, we'll be publicising it when it is ready. Okay, we've had a question about what the kind of cultures that lead to sexual harassment in the first place and what actually allows them to thrive. And the misogyny in a workplace can often be a cause of this. So are employers going to be expected to prevent misogyny initially, so that it then leads on to tackle sexual harassment?
So there's no mandatory requirement on employers to tackle misogyny. But if there is a culture of misogyny and inappropriate, sort of conduct or, banter, so to speak, then that is a risk factor which can contribute to sexual harassment. And we would expect the employer to consider workplace culture as part of its risk assessment, and then to look at what steps it can take to address that. And I'm not going to sort of set out an example of the type of action that an employer should take in response to that. But I think it's worth reflecting that many organizations have, sort of separate strands of activity on values. So I think it's really important to kind of tie compliance with the preventative duty to where you have existing values in terms of treating people with dignity and respect that sit outside, say, sort of, formal compliance with the Equality Act. So that's definitely one thing. There are other things as well that also sort of contribute to this, which includes things like there being a gender imbalance in the workplace. So if it's a predominantly male workforce, or if senior people are predominantly male, and that, so you have that power imbalance, that's another risk factor. And this is all clearly detailed in the resources that we have, and as being one of the areas for consideration for employers. So hopefully, by sort of being explicit that these kinds of things, these sort of workplace culture issues, can exacerbate the risk of sexual harassment, that might be really helpful to prompt for employers to start considering what behaviour looks like in the workplace and how people interact with each other.
Thank you. And linked to that point about behaviour in the workplace, we talked at the beginning about reports of sexual harassment and how we get we get some formal reporting, but then there's often informal or rumour. How can we, so I've got a question both for you and for the audience, so the audience can put some examples in the chat panel. Have we got any good examples of ways employees can be made to feel comfortable to make those formal reports of sexual harassment? Our viewers, let us know if you've implemented something or you've heard about something. And Rebecca, have you got any that have reached you at the EHRC that you've heard about?
So again, I'm not much use to you in terms of specific examples, but I think in terms of employee responses, one of the things we really strongly encourage is for an employer to have multiple reporting routes and to make sure that those are confidential. And that will hopefully sort of build confidence in terms of people being able to, disclose concerns, make sure that they can report anonymously, make sure, that the reports through reps, through branches, can be fed in so that employers are kind of understand where there might be particular areas of, particular problems, particular failures, and then they can take steps. And then hopefully, as I said, this is kind of leading towards culture change within workplaces, and it's not going to happen overnight. It's going to be gradual. But what we want absolutely is, what we want is for sexual harassment not to happen. But trying to sort of legislate for that is really, really difficult. So what we want is to create workplaces where harassment is just not tolerated, and that people feel confident and secure knowing that their employer has got their back, and that they are going to be listened to, they're going to be taken seriously, and that action will happen off the back of that, so that they are protected, either in terms of the kind of the immediate situation, or that the workforce more generally going to be protected in terms of future instances of sexual harassment.
Thanks, Rebecca. And we've had one or two posted in the chat, so I'll just sort of highlight those. One viewer has said that we may have seen these sort of Ask Angela style posters that you sometimes get in pubs and restaurants.
Mhm.
They've had a similar type thing in their workplace, or a QR code where people can perhaps report online if they don't feel comfortable speaking in person. I'm just trying to see where the chat has sort of moved, so
Yeah.
I can't see where it's gone. But some really hopefully good examples there that the people can take a look back on. Okay. Another question we've had is there going to be any protection for workers who might raise concerns about non-compliance? Do they, are their names taken? Would that be then, if the employer is approached in investigation, what sort of protection does that individual get?
What, in terms of people contacting the EHRC raising concerns?
Well,
I
yes,
think,
it says about
yeah,
non-compliance with the duty, so that's the point
yeah.
that would come to you, right?
So I think the point just to remember under equality law is that, you are protected from detriment. You're protected from victimisation if you make a disclosure around harassment or discrimination anyway. So there are victimisation provisions within the Equality Act designed to protect people from detriment or negative treatment as a result of making a disclosure of harassment or discrimination. There's also the whistleblowing protections that means if an individual contacts us, they have sort of an additional level of protection through the whistleblowing sort of legal framework. In terms of the kind of the practicalities of making a disclosure to the EHRC, I can't give you chapter and verse in terms of what that looks like. I'm certainly happy to get more detail on what happens if an individual makes a disclosure to us, but we absolutely would treat any disclosure in confidence, and we would be liaising with the individual who's made the disclosure to us to determine what it is that they want us to do and how we can kind of best support them throughout that process.
If it does, I mean, I appreciate this law is 3 weeks, less than 3 weeks old, so it's very early days. But what will the EHRC literally do if they are if something is reported to them? What will the action look like? Do they go in and do an investigation, ask for more evidence? How does it play out?
So there are a number of steps that our enforcement team would take, and that would very much be around sort of gathering evidence in the first instance to determine the kind of the issue and the severity of such. We have a hub that sort of triages disclosures that are made to us about breaches of equality law, and that will review all of the available evidence with and then we will sort of discuss whether what type of enforcement action might be appropriate in that instance. So if you look at, there are lots of examples online in terms of EHRC's enforcement activity relating to sexual harassment. You can find those on our websites. With some high profile ones we've done recently is things like we've entered into legal agreements with Sainsbury's and with McDonald's because of concerns raised to us about sort of systemic problems with sexual harassment. And when we enter into a legal agreement, and that's very much a kind of an end point, what that obliges the employer to do is to enter into, is basically to come up with an action plan. So steps that they will take to rectify failures, sort of historical failures, and sort of proactive steps they will take to demonstrate that they're meeting with the preventative duty.
Thanks, Rebecca. So we've had like quite an overarching question here about jurisdiction. So does the question is, this new duty under the Equality Act, is there an equivalent under the DDA for people in Northern Ireland? Does it cover Northern Ireland, or is there an equivalent under the the older legislation?
My understanding is that there's no equivalent duty in Northern Ireland. So the Equality Act only applies to Britain, so that's England, Scotland and Wales. And the EHRC is only responsible for enforcing across those 3 countries. I know there's lots of interest in a similar duty in Northern Ireland, but I'm not clear on where they're up to.
Okay, thanks for that. Right, I want to save the last batch of questions that we've got are all about the third party element of this, because it's come up quite a few times. And we referred earlier to third parties are someone who maybe isn't an employee. So a customer, a patient, we're members of the public. We've had a question saying that the new legislation specifically protects police officers. But what about other people who work in public facing roles, for example, healthcare, mental health? And we've had someone also, a couple of points come in the chat about either education, like in a college, or in prisons. So there's all third party. I appreciate this is extremely broad definition of third party.
Yeah.
But I thought we'd save these subjects for the last quarter. So any thoughts on those?
So yes, absolutely. Workers in all of these different settings are protected from sexual harassment by third parties. The challenge we have is, how does the employer then implement preventative steps? How do they sort of do their risk assessment and understand where the risk factors are, which might lead to individuals in those contexts being sexually harassed by a customer, a client, a patient, a service user, or so forth. And that's why we can't be prescriptive, because if we tried to anticipate every single possible risk factor in every single setting, you know, we'd probably be bigger than the internet in terms of the advice and the resources we have. So again, this speaks to the absolute value of reps in terms of sharing insights and understanding on the kind of challenges that members face in the workplace, and what might be a reasonable response on the part of the employer to make sure that they are protected. So as I said, if you look at the technical guidance, there are a number of examples which give some insights in terms of third-party harassment and how you might deal with that. You know, and it ranges from kind of really low-level things to sort of making it explicit through, you know, materials that are publicly available, posters or whatever, or, you know, sort of verbal instructions to make it clear that the employer doesn't tolerate harassment, sexual harassment of its workers, whether it's a worker on worker or whether it's a third party. Absolutely. And that's a really easy, you know, sort of and clear thing to do. You can quite clearly point to something and, you know, call people out on behavior. But at the end of the day, you know, there are other sort of challenges and risk factors, which includes things like lone working, for example. We all know how stretched a lot of public services are, where, you know, sometimes staffing ratios aren't sufficient. So there are additional risks there, and they need to be considered and mitigated. And ultimately, it's down to the employer to try and find ways to ensure that its workers are protected in each of those different settings, so that the risk of harassment by third parties is limited.
Thanks for that. I think, yeah, obviously we need to almost see how things go over the next few weeks to really I guess get evidence of how this law will play out. We've had a question a couple of times about the situation regarding volunteers within organisations. What's the deal with them? Are they also protected? And how are they considered under this law?
So volunteers are not formally covered under the legislation, under Equality Act. But I would argue that, you know, if an employer is reliant on a substantial number of volunteers to deliver its business, then it makes sense to ensure, as part of the preventative duty, that you are considering where an individual might be at risk of sexual harassment if they're a volunteer. Because, you know, it's about sort of creating systems and having sort of mechanisms in place to make sure everybody in the workplace is supported. And you know, there's no reason why volunteers can't be included in that. It's just that they don't have formal legal status under the Act.
So would they be able to rely on the enforcement aspect of it?
They could certainly make a disclosure to the EHRC. Yes.
Okay, thanks. I think hopefully because we have quite a few questions about volunteers, hopefully that's clarified some of the issues. Okay, we've had a question that is I'm not sure whether it's covered under this new act, but it is related to sexual harassment, so I'm still going to put it to you. Would a failure by an employer to take reasonable steps to prevent sexual harassment be enough for a constructive dismissal? I mean, again, it's brand new law. We probably haven't tested it yet, but do you see this as being something that might come up in months to come?
Sorry, can I clarify? If the employer, if like there was a single representative of the employer, if they failed to take reasonable steps, they could be constructively dismissed.
No, it doesn't say, but
Right.
I took it to be if a person was on the receiving end of sexual harassment and the employer failed to take reasonable steps to prevent, would that then, that's how I took it, but I'm not sure actually. Now you've given me the alternative understanding.
What you said makes far more sense. So yes, if an individual has to leave as a result of the employer's failure to deal with sexual harassment and then claimed constructive dismissal, but it would presumably also be tied to sexual harassment at the tribunal, and the tribunal could consider then if there's been a breach of the preventative duty. So potentially, yes. I think obviously it would depend on the sort of the facts of the case, but if an individual has experienced sexual harassment and that's given them, they feel they've got no alternative but to leave, and then they take a constructive dismissal claim, then presumably part of the particulars of the case will be that they set out the harassment they've experienced, and they could also say we consider that the preventative duty has been breached. Can I just qualify this by saying I'm not actually a legal professional, but that is my understanding of it.
Well, for sure. I mean, and also, like I keep saying, this law is like 3 weeks old. So we really, some of it has yet to be seen about how it
Yeah,
develops really, and what cases are brought under it.
absolutely. Yes.
Just does the law state, or have we got other examples really of what exactly we mean by third party? Is it someone who's not the employer, not the employee? We've both given loads of examples, haven't we? Of like, be they customers or patients or students, etc., etc. What else? Is there a kind of definition that we can use that gives us some clarity?
My understanding is that there's no actual legal definition of what constitutes a third party, but yeah, it's that kind of process of elimination. It's not the worker, it's not the employer, it's any individual that the worker would come into contact with during the course of their employment. So it could just be a passing member of the public through to a sort of a contractor or a supplier through to a customer or a service user or whatever. Yeah, it's very, very broad.
Yeah, so someone sort of not in a kind of, I was about to say, not in a legal relationship with the employer, but if they're a contractor, then they are, aren't they? So it's not even
Yeah,
that the case. It's really broad, isn't it? So basically anyone else.
yeah, that's
Someone has just said like frontline healthcare, the comment that's just come up, it would include patients, I guess family of patients,
yeah,
service users, anyone really who comes into your workplace or that you deal with in the course of your work.
yeah, absolutely. And I think if you look at a lot of employers already, there are very clear public statements about how they expect staff to be treated with dignity and respect in their workplace, whether that's in hospitals or whether that's in train stations or wherever. So it's not a huge stretch to expect an employer to be explicit about the fact that their workers are entitled to work free from the threat of sexual harassment.
Thanks. Rebecca. And the final question, which I think is really good to end on, is this law retrospective? If or is it only from the day which I think you gave as the 26th of October? What if there is a historical failure to prevent sexual harassment, and where a culture has maybe developed that allows this? What's the story then? Or are we like 26th of October is day one?
So it's 26th of October is when the preventative duty came into effect. So absolutely, it's not a retrospective duty. But if the EHRC was going to take enforcement action based on disclosures of harassment prior to that date, if, you know, as I said, we go to sort of the kind of the really robust enforcement action we take and we enter into a legal agreement and the employer is required to set out an action plan, it would very much look at, well, what are you going to do then to demonstrate compliance with the preventative duty? So from a rep's perspective, if there is sort of, you know, a history of poor responses on the part of management and a failure to actually properly address sexual harassment, in some ways it's a good, not in a good way, but a helpful roadmap for reps to go, this is what our members have experienced historically, this is where we expect you to take action. We consider that it is entirely reasonable for you to do this because this is how our members have been treated, and how they have been harassed, you know, over recent months or years or what have you. So you know, it's a moment in time. We kind of need to pause and look to the future, and it is going to take time. But actually, all of the insights that reps have in terms of how their members are being treated, what workplace cultures and behaviours are like, are incredibly helpful towards, you know, sort of pushing the employer to be proactive and to take its obligations seriously.
Thanks, Rebecca. And I think that's a really helpful note for us to finish on. As we said, we at the TUC are currently working on some updated e-learning modules for you about this to include the new law. The EHRC have lots of helpful information on their website that goes into incredible detail. So do take a look at that, and we will all send you the links. We'll be sending those out tomorrow morning, along with a link to the recording. But thank you all so much for joining us today with your really insightful comments and your questions. And thank you so much, Rebecca, to you for joining us. You've been incredibly helpful and really detailed answers to all the questions we've had. No appearance from the cat, which I'm a bit disappointed about, but maybe they've gone off for the okay, they're just out of shot. Okay, amazing. But thank you so much for joining us today. I will see you all again for another webinar in a couple of weeks, which is going to be about updates on pay. Do join us for that, and see you all again soon. Bye bye for now.